The courtroom buzzed with quiet murmurs that Tuesday morning, filled nearly to capacity. From where I stood, I could practically feel Karen Whitfield's smugness seeping across the room. She sat confidently in a sharp business suit, lips pursed with that irritating air of moral superiority, whispering to her lawyer as though the outcome had already been sealed in her favor. In her mind, she was moments away from putting the unruly rancher in his place. At least, that's what she believed, until Judge Morrison opened the session and asked whether I had legal representation. I rose slowly, straightened my tie with the ease of habit, and responded, "Your Honor, I'll be representing myself." That earned a smirk from Karen's lawyer, a young man named Bradley Cooper. He chuckled lightly. He clearly hadn't done his homework. "Very well," Judge Morrison said. "Please state your qualifications for the record." I cleared my throat and spoke calmly. "Thomas Mitchell, retired attorney. Spent 35 years practicing at Mitchell & Associates, focusing on property and civil law. Member of the State Bar since 1987. The grin slid right off Cooper's face. Karen's expression faltered too, her mouth parting in surprise before she collected herself. Truth be told, I hadn't planned on spending my retirement this way. Life at Cedar Ridge Ranch was meant to be peaceful. After decades tangled in courtrooms and boardrooms, I bought the 100-acre ranch to finally enjoy some quiet. No neighbors in shouting distance, no HOAs to bother me, just open skies, horses, and the occasional visit from my grandkids. The land had belonged to the Henderson family for 3 generations before it came to me. Old Jim Henderson had been clear. This property was never part of any homeowners association. The closest subdivision, Willowbrook Estates, was 2 miles away and separated by county land. For the first year, life was blissful. Then came Karen Whitfield. She'd just been elected president of the Willowbrook HOA when she first arrived, pulling up in a spotless white Lexus one cool October morning. I was fixing a section of fence when she stepped out, clipboard in hand, every hair in place. "Excuse me," she called out, her voice clipped and expectant. "I need to speak with you about trail access." I put down my hammer and approached, stopping at the gate. "Can I help you?" "I'm Karen Whitfield, president of the Willowbrook Estates HOA," she said with an air of importance. "We're building a community trail system and need to place an easement across your land to connect to the county's hiking routes." I nearly laughed. "Ma'am, this is private land. It's not under your HOA's authority." Her smile twitched. "That's what we need to discuss. The community believes connected trails will boost property values and support active lifestyles." "Well, that's wonderful, for your community," I replied evenly. "But this ranch has never been part of Willowbrook. And it won't be." She tapped her clipboard with a perfectly manicured nail. "Mr. Mitchell, I don't think you understand how these things work. When a community decides something is for the greater good, individual property owners can't simply stand in the way." That was the moment I knew she'd be a problem. "I understand just fine," I told her. "But the answer is still no. Enjoy your day." I turned back to my repairs as she stormed off. Over the following months, her efforts intensified, from annoying to outright unlawful. I began receiving letters, all bearing the HOA's official seal, demanding I attend board meetings. I ignored them. Then came bogus complaints to the county about supposed violations, each one wasting my time with inspectors who left shaking their heads in disbelief. She organized neighborhood wellness walks that just happened to end at the edge of my property. Crowds would stand there snapping photos like they were on safari. The real turning point came in April. I found my back gate unlocked, the padlock cut, and fresh tire tracks crisscrossing my land. Trail markers had been nailed into my trees. I spent the day pulling them all down and installed motion-activated cameras. What I captured was shocking, though not surprising. At 2 a.m. the following Tuesday, Karen herself appeared on camera. She was holding bolt cutters, flanked by 2 HOA board members. I watched them break through my gate and install new trail markers along my private road. The next day, I had a crew weld in a heavy-duty steel gate and sink the posts in concrete. My attorney at the time sent them a cease and desist letter. That should have ended it. Instead, she doubled down. A process server knocked on my door that Friday afternoon, delivering a thick envelope. Karen Whitfield and the Willowbrook HOA were suing me. The charges? Obstruction of community resources, interfering with easement rights, and my favorite, creating a public nuisance. They demanded removal of my barriers, $50,000 in damages, and their legal fees covered. The claims were laughable, fabricated from start to finish. They invoked historical use, alleged that my land had once been part of a parcel under public access commitments. Complete fiction. But it required a formal response. I figured there was no need to hire anyone. This was my wheelhouse. I filed a counterclaim accusing Karen and the board of trespassing, harassment, and defamation. Then I dusted off my old legal files and began preparing for the fireworks I knew were coming. Karen, for all her bluster, had no idea she'd picked a fight with someone who used to chew up lawyers for breakfast. On the morning of the hearing, she showed up with a full entourage, her attorney, 2 board members, and someone scribbling notes who probably worked on the HOA newsletter. She wore an HOA pin on her lapel, like it was a badge of authority. Judge Morrison, a seasoned woman I'd appeared before many times during my career, didn't recognize me at first. But when I stood and listed my credentials, her eyes narrowed slightly in recognition. "Mr. Mitchell," she said with a knowing nod. "Welcome back to my courtroom." Bradley Cooper, Karen's flashy but inexperienced attorney, rose to deliver his opening remarks. With exaggerated gestures and a confident tone, he tried to portray me as some bitter loner standing in the way of happy families enjoying public trails. According to him, the paths had been there for decades and I was selfishly cutting off community access. Karen, he claimed, was simply doing her duty as HOA president to protect the neighborhood's interests. When it was my turn, I didn't match his theatrics. I kept it factual. "Your Honor," I said, "this is the original deed for my land from 1952, a certified property survey from when I bought it in 2021, and notarized statements from the last 3 owners spanning 60 years. I laid each document out on the table, watching Cooper's confident mask begin to crack. "There has never been an easement on this land. It's never been part of an HOA, nor has it ever been open to the public." Then I pulled out a folder. "Here's security footage of Ms. Whitfield trespassing on my property on at least 6 separate occasions, breaking locks, placing signs, and installing markers without permission." I handed the judge printed stills from the footage. "And here are 17 harassing letters she sent me, records of 9 false complaints she made to county offices, and documentation of a smear campaign she orchestrated against me within the neighborhood." Judge Morrison's eyebrows climbed as she looked through the evidence. "Ms. Whitfield, is this you in these images?" Karen's smug expression evaporated. Her face turned red. "That's out of context," she blurted. "The community needed access to those trails." "So you admit you trespassed?" the judge asked. Cooper jumped up to defend her. "Your Honor, my client believed there were easements. She acted in good faith." I kept my tone level. "And here, Your Honor, is Exhibit C, a recorded phone conversation between Ms. Whitfield and another board member. Her exact words were, 'I don't care if he owns it. We'll make his life hell until he gives in.'" The courtroom fell silent except for the sound of Karen's sharp gasp. "That was private," she cried. "It was recorded from my yard," I replied, "during one of their loud meetings. This is a single-party consent state. It's perfectly legal." Cooper scrambled, trying to pivot the argument toward community good, but it was clear the damage was done. Judge Morrison looked unimpressed. "Counselor," she said, turning to him, "do you have any documentation proving the existence of an easement?" He fumbled through his briefcase, clearly grasping. "We're still searching historical records, Your Honor." "So that's a no?" she asked flatly. "Yes, Your Honor," I replied. "And I'd like to proceed with my counterclaim. For damages due to trespassing, coverage of legal fees, and a permanent restraining order preventing Ms. Whitfield and any HOA personnel from setting foot on my land." Karen leapt from her seat, her voice shrill. "You can't do this. I'm the HOA president. I have authority." Judge Morrison's gavel hit the bench hard. "Sit down and be quiet, Ms. Whitfield, or I will hold you in contempt." She turned to me. "Mr. Mitchell, your evidence is compelling. I'm prepared to rule in your favor on every count." Cooper tried one final plea. "Your Honor, We request a continuance to gather further documentation. Denied. The judge said sharply. I've seen more than enough. Over the next 20 minutes, she systematically dismantled every single one of Karen's claims. Each one was dismissed with prejudice, meaning she couldn't bring them again. My counterclaims were granted in full. Karen was ordered to pay $15,000 for trespassing, plus $5,000 in legal fees. Far less than the actual cost, but I didn't press. Most importantly, a permanent restraining order was issued, forcing her to stay at least 500 feet away from my property. But the judge wasn't finished. Ms. Whitfield, she said coldly, your conduct throughout this case has been disgraceful. You've misused your position, harassed a private citizen, and wasted the court's time. Counselor, she added, turning to Cooper, you might want to review the bar's rules on due diligence before filing again. Consider this a formal warning. Then came the final blow. This case will be referred to the district attorney for possible criminal trespassing charges. And I'll be forwarding this ruling to the Willowbrook Estates HOA board with a recommendation they reconsider their leadership. Karen looked as if the floor had dropped from beneath her. I was just trying to do what was best for the neighborhood, she whimpered. No, the judge replied icily. You were trying to strong-arm someone into giving you what you wanted. That is not the same thing. As we exited the courtroom, Karen was swarmed by furious HOA members who'd witnessed the entire hearing. I overheard them whispering about emergency meetings and removing her from office. Cooper slipped away without saying another word. 3 days later, I received a certified letter from the HOA. Karen had been unanimously removed from her position and barred from holding any future office within the organization. 2 months later, she pled guilty to criminal trespass. The sentence? A year of probation and 500 hours of community service. None of it allowed to involve any HOA-related work. The best part came 6 months later, when I was invited by the state's law school to give a keynote presentation on property rights and HOA overreach. I titled the lecture, When Karen Attacks, a Case Study in Abuse of Power. The security footage and transcripts from our case became central teaching material. The talk went viral on legal forums. Karen's legacy didn't end with a grand community trail system. It ended as a case study in arrogance and overreach. She quietly sold her house at a considerable loss and moved out of state. The new HOA board sent me an apology letter and a fruit basket. I donated the full $20,000 I received in damages and legal fees to a nonprofit that helps homeowners fight unfair HOA practices. They honored the donation by naming their new meeting room the Whitfield Warning Room. Last I heard, Karen was working as a receptionist at a small real estate office 3 states away. Her days of wielding power were long gone. Buried beneath a criminal record, court rulings, and a humiliating legacy that would live on in legal classrooms for years to come.